A big win for the Trump administration in a major federal court. The United States Court of Appeals for the D.C. Circuit has just ruled in favor of the Trump administration that indeed they can, for all intents and purposes, shut down the voice of America overseas and related entities. Let's break down what this means for all of us when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so if I'm in a suit, it means one of two things. Either I just appeared on the Fox News channel, or I'm trying to compete with William Kirk over at Washington Gun Law to be the most dapper person in the Second Amendment movement. Well, I know I can't compete with William Kirk for being the most dapper person out there, so obviously I just appeared on the Fox News channel, and I just appeared on Fox and Friends talking about a lot of different issues, so that's why I'm in a suit today. So with that said, I want to talk to you about this major victory for the Trump administration, break it down a little bit so you can start to understand a little bit about some of the nuance here, and something you'll probably read in the paper. Now, as you know, I generally like to cover Second Amendment news, but sometimes we have to cover some of this other legal-related news because, again, as I've explained to you before, if the Trump agenda fails, if Donald Trump does not succeed as president, then we're going to have a big problem with our Second Amendment because if you get a, President Kathy Hochul in there, President Pritzker, President Gavin Newsom in there, we're going to have problems with the federal courts, among other things, when it comes to our Second Amendment rights. We really want the Trump administration to succeed, as well as any other Republicans out there. I know no one is perfect, but certainly when you compare the Republicans and Democrats when it comes to our Second Amendment rights, the Republicans are far superior by all measures than the Democrats. And that's just my view, but I'm pretty sure I'm right on this. So with that said, it's good to see another major win by the Trump administration dealing with this issue involving the voice of America and related entities. Just to jog your memory, there is a process, or I should say the Trump administration is trying to shut down the deep state out of fear, and rightly so, that much of, if not all of the deep state poses a grave risk to individual freedoms and our Constitution and the American way of life. Unfortunately, a lot of the money that's gone out the door from our pockets as taxpayers, either through taxes or through inflation, inflating away the value of the money in our bank account, let's say, a lot of this money has flowed to left-wing groups to advance left-wing talking points and propaganda. And a great illustration of this is the Voice of America and some related entities such as Radio Free Asia, Middle East Broadcasting Networks, and so on. At least from the point of view of the Trump administration, they view these broadcasting entities, if you will, to be broadcasting kind of propaganda that's anti-American across the world. You can disagree with that, but that is the view of the Trump administration, including Kari Lake, who oversees all of these entities. So what happened, of course, is as part of the DOGE effort, Donald Trump and his administration are trying to cut back on the number of federal employees, cut back on the number of grants that our taxpayer dollars goes to sort of nonprofit organizations. And part of this process of cutting back on the deep state included cutting back dramatically on the reach and the money spent and the employees employed by and the contractors contracted with the Voice of America, which again, historically is a radio broadcasting network that broadcasts kind of supposedly objective American news across the world. But the reality is, from the Trump administration's point of view, it's just another way that the left-wing agenda gets pushed out there, no different than NPR and PBS. Here domestically, Voice of America is kind of that version overseas, and the Trump administration wants to shut down this nonsense. Now, so what Donald Trump did is he went out there and directed in March that all of the spending on these various programs by the deep state needs to be shut down. There should be administrative leaves employed. People should be fired. And essentially any agreements that have previously been entered into by the Voice of America and these related affiliates needs to basically be shut down to a bare minimum under the statute. And I think over 1,000 people were fired and so on to try to save money, not just save money of the American taxpayer, but also prevent left-wing propaganda from being sent out there throughout the the world. At least I think that's the point of view of Kari Lake and the Trump administration. Now, after this occurred, what happened, of course, is you have lawsuits brought in federal district courts. And remember how I've explained to you before, to be the best possible advocate for the Second Amendment right to keep and bear arms and all of our constitutional rights, it's extremely important that you understand the process whereby a case goes womb to tomb through the court system. You don't want to just understand the merits of an issue. You also need to understand the process, because it does no good to be right on the substance of the law or the facts if you screw up the process and procedure. And that is exactly what's going on here. Specifically, all these folks that were adversely affected, allegedly so by the Trump decision. These are contractors, these are agencies, these are employees that work for these agencies. They brought lawsuits in the United States district courts. Specifically, these are the federal trial courts, which you're quite familiar with from the Second Amendment fights. But there's two major problems with this, and we're going to get to those in just one second. But of course, what happens is you have these typical deep state judges in the District of Columbia, and a lot of these cases went to the District of Columbia, where you have these DC-based judges who are buddies with all of these DC government employees, right? They all swim in the same water. They're all part of the same industry. If you think about it, judges that have homes in the DC area hang out with their buddies that work for the federal government in the deep state in the DC area. They all join the private clubs that all are touching fingers with the deep state DC area doing DC related stuff, which is really unproductive in all respects. They're very good at taking money from the American taxpayer and spending it in the area and spending it on nonsense, but they get to keep a piece of the action, which of course is why if you look at the top 10 or 20 zip codes in the United States when it comes to home prices or net worth or net income, however you want to measure it, some of the wealthiest parts of the United States are in and around the DC area, because they can put a gun to our heads and force us to send our money to them so they get to spend it. But in the process, of course, they keep a little piece of the action. It's a good gig if you can get it. So anyway, the point being that a lot of these judges in the DC area, not all of them, but most of them are basically creatures of the deep state. I have some solutions for this, which I'll cover in a separate video. But for the purposes of this video, just understand that most of the judges that work in DC are interested in advancing, are part of the deep state apparatus, if you will, and they're sympathetic to government. So in that context, what happened is you had these lawsuits brought in, of course, the district courts in the District of Columbia, DC place, right? And guess what? One of the federal judges here entered injunctive relief in favor of all these plaintiffs against the Trump administration. No shock, because as I explained to you before, it's pretty clear that these blue state judges in Boston, in San Francisco, in Chicago, in New York City, in DC in particular, they're all looking for ways to bog the Trump administration and the Trump agenda down in any way they possibly can do so, because they're part of the problem. So the DC judge here, Judge Royce Lamberth, specifically entered these injunctions against the Trump administration and said that the Trump administration must continue to broadcast with a full staff as previously set up, the Voice of America and all these other things like Radio Free Asia and Middle East broadcast networks and so on. So basically you have a federal district court judge in DC telling the Trump administration, the President of the United States, that he must continue to broadcast foreign policy information across the globe on these various radio networks. Now, I'm happy to report, though, in a big win, a 3-judge panel heard an immediate appeal from the Trump administration, and the Trump administration said, we want an administrative stay. We want a stay of this injunction that the district court judge entered, that if it's not stayed, the district court is telling us we must continue this foreign policy. We must continue to pay these people money. We must continue to broadcast these messages. And that is inconsistent with our view and the proper view of the Constitution, which is we, the executive, we, the president, we, the executive branch, get to dictate how this goes down. And you, Federal district court judges, for example, cannot override what the president has to do when it comes to foreign policy. And I'm happy to report that a 3-judge panel in the United States Court of Appeals for the D.C. Circuit agreed with the Trump administration. They specifically said that the plaintiffs that brought this lawsuit, remember I told you process is very important? They specifically said that all the plaintiffs that brought these lawsuits against the Trump administration did so in the wrong way. The first thing they said is to the extent that you have contract claims against the federal government, you cannot sue for breach of contract in the United States District Courts of America. If you're seeking contractual relief, meaning you have a contract, there's an agreement, and someone's breached it, you have to sue under the Tucker Act in the United States Court of Federal Claims, based in a beautiful building in the District of Columbia. And here, you cannot have a district court judge using the Administrative Procedure Act enter an injunction compelling the president to continue to pay these people, because when you start talking about money, you start talking about contractual obligations, that sounds in a breach of contract. If you have a breach of contract claim, meaning you claim that the government owes you money under a contract that the U.S. government has with you, you have to go to the United States Court of Federal Claims and sue there. That's what you have to do. And instead, they sued in the United States District Court system, and that was the improper jurisdiction, according to this 3-judge panel. And this panel laid it out in great detail in a 2-1 decision for the Trump administration. The other point that was made here is that there were federal government employees that sued the Voice of America, that sued Kari Lake, that sued the Trump administration. And these federal employees said, we want our jobs back, we want to be paid, all sorts of things like this, all sorts of arguments. And again, the Court of Appeals for the D.C. Circuit said, no, you're in the wrong place. Specifically, and this is such a crazy list, if you think about how crazy it is, if you're a federal employee, here are all the different places that you as a federal government employee can seek relief from. And this is according to the U.S. Court of Appeals for the D.C. Circuit, pointing out that suing in federal district court as a federal employee is verboten. That's not where you're supposed to go. You have to go to one of these other grievance procedures that have been long established. And they didn't do that, so they got kicked out of court for all intents and purposes. Here's the list that the D.C. Circuit pointed out to those federal employees suing because they lost their jobs or they're being denied promotions, whatever it is, against the Trump administration. The D.C. Circuit said that Congress has established a comprehensive statutory schemes for adjudicating employment disputes with the federal government. And then it goes on to list some of these. It lists the Merit Systems Protection Board. It lists the Office of the Special Counsel. It lists the Federal Labor Relations Authority. It lists the Foreign Service Grievance Board. It lists the Civilian Board of Contract Appeals. And the court goes on to say, these remedial schemes provide the exclusive procedures, hear what I just said, the exclusive procedures by which federal employees may pursue employment and contractor-related claims. Again, if you're suing over money and you're an employee, you go through one of these processes, or you have to go to the United States Court of Federal Claims. You cannot try to get around that by going to the United States District Courts. And that is exactly what this decision says. So this is a big win for the Trump administration because it's reaffirming what Justice Alito said just recently in a Supreme Court ruling that says, if you're suing about money, if you're suing about losing your job, if you're suing about some NGO, nonprofit contractor grant that you're supposed to get from the federal government that you never got, you got to go to the U.S. Court of Federal Claims. Now, this is great for the Trump administration for several reasons. Number one is these claims will take many years to go through the system. And that's great because, frankly, as far as I'm concerned, it's about time that the liberals get to experience the slowness of the court system, because every time you and I turn around, we have, Second Amendment claims take years and years and years to wind their way through the court system. And we're sitting around going, when are we going to get a decision? When are we going to hear from the Third Circuit? When are we going to get a ruling? When is the Supreme Court going to hear this case? And we've been dealing with this for years and years and years. And frankly, from my point of view, maybe this is not the right way to live life, but from my point of view, it's about time that some of these lefties out there get to experience the slowness of the court system in the same way that we in the Second Amendment community have had to suffer for so many decades. But beyond that, of course, it also bears mentioning that the Court of Appeals here points out there's another critical thing to understand, that it's simply wrong that a federal district court judge tells the executive branch what to do when it comes to foreign policy. Here's what the Court of Appeals for the D.C. Circuit had to say when it comes to making sure that district courts don't encroach upon the foreign policy decision-making and ability to speak with a single voice on behalf of the President of the United States. This is what they wrote. The federal government has shown that it will face irreparable harm absent a stay here. As to the reinstatement of these employees and personal service contractors, the executive branch, that's President Trump, has a significant interest in maintaining control over personnel matters. Moreover, in requiring the restoration of all employees and contractors to their pre-March 14th status, the injunction interferes with this important responsibility. This intrusion by the district court is particularly harmful because it implicates the executive branch's foreign affairs authority. The entity responsible for presenting the views, meaning the Voice of America and the related entities, is responsible for presenting the views of the United States government and supporting the United States foreign policy objectives in the international community. By depriving the executive branch of control over the individuals involved in its international broadcasting, the injunction threatens its prerogatives to speak with one voice on behalf of the United States in foreign affairs. That's powerful stuff. Again, anything that touches with international affairs or foreign affairs as a general matter, courts are not supposed to be involved with that. In fact, if you go back to the Vietnam War era, there's a very famous case involving the bombing of Cambodia. There was an attempt to stop President Nixon from bombing Cambodia on the grounds that it was unconstitutional and illegal for the president to be bombing Cambodia without proper congressional authority, let's say. But at the end of the day, the U.S. Supreme Court says, look, there may be a legitimate constitutional question here about whether or not President Nixon has the legal authority to bomb Cambodia. But that's not for we, the courts, to decide. That's up to the fight between the president, the Congress, the congressional budgets, we the people, elections, and so on. So even though there may be a legitimate legal or constitutional question, we, the courts, are not institutionally capable of resolving that debate because it touches on international affairs and foreign responsibilities of the president. And that is simply not what we do. That's up to that branch of government, and we're not going to touch that, is essentially what the Supreme Court said dealing with that issue. And that precedent is just as true today and applies equally to today's situation, which is when you start dealing with foreign policy affairs, the federal court system, as a general matter, needs to butt out. And that's basically black letter Supreme Court precedent, by the way. And the only other point I want to make on this video is we've talked about the importance of posting bonds. In fact, I think I was one of the earliest people that pushed out there to let everyone know on X. If you're not following me on X, make sure you are at 4Boxes Diner. I'm one of the early people pushing out that under Rule 65 of the Federal Rules of Civil Procedure, if you're going to get injunctive relief against, for example, the Trump administration, these plaintiffs should be forced to post bonds. So what happened here is, again, the district court judge gave all this fantastic relief in favor of the plaintiffs against the Trump administration, but did not require them to post a bond. And the purpose of posting a bond when you receive an injunction is if it turns out that an injunction was wrongly issued, the person that was restricted by the injunction gets to recover money that makes them whole again. So if you force me with an injunction to pay out $1 million, the other side has to post a bond for $1 million so that if it turns out I'm right and you're wrong, I get my $1 million back pursuant to that bond. Here, the federal district court judge conveniently decided not to require the posting of the bond. And the U.S. Court of Appeals for the D.C. Circuit here specifically pointed that out as yet another reason why the lower court injunction needed to be stayed or paused because it was wrongly entered. Here's what the court said. The U.S. Court of Appeals wrote, quote, "As to the restoration of the grants, absent a stay here, the federal government would be forced to imminently pay out some $15 million to the plaintiffs. And the plaintiffs have attested they intend to spend these monies immediately. Because the federal district court did not require plaintiffs to post any injunction bond, the federal government cannot recover these funds, even if it should prevail in its appeal. Under these circumstances, harm to the federal government is irreparable." Exactly right. If I'm going to ask a federal court to pay me $1 million from you, well, you should be demanding, and the federal district court should be requiring that I post a bond, because if it turns out I get the $1 million wrongly, let's say, and you win the case, you need to be guaranteed that you're going to be made whole. And the only way to guarantee that is with the posting of the bond, that should I lose and you win, the bond pays out to you the $1 million that you had to pay to me. That is the notion of posting bonds, to make sure that if it turns out down the road the injunction was wrongly entered, the party that had to comply with that injunction is fully compensated financially for the harm associated with that. And again, these bonds have not been, they should be required, and they are supposed to be required under Federal Rule of Civil Procedure 65. But again, these federal district court judges that are pro-deep state, anti-Trump, are not requiring the anti-Trump lawsuits, the anti-Trump plaintiffs to post bonds. And guess what? That is a problem. And it's good to see at least one court, the U.S. Court of Appeals for the D.C. Circuit, to flag this and say, if you're not posting a bond, you're not getting an injunction. It's simple as that. So anyway, hope you enjoyed today's episode. Make sure you follow me on X at @4boxesdiner. Don't forget to subscribe both to YouTube and Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.